So we were discussing the topic Supreme Court, and yesterday we had started our discussion with the appointment and removal. The appointment of the judges of the Supreme Court, we have seen the developments from the first judge case, the second judge case, and finally the third judge case, which established a collegium system in India. And currently the appointment of judges basically takes place through that collegium system. We had also seen that how the 99th constitutional amendment wanted to create a body called as the National Judicial Appointments Committee, but this National Judicial Appointments Committee was declared unconstitutional by the court on the fact that, according to the Supreme Court, this was encroachment on the part of the executive on the independence of the judiciary. Then we went to the removal of judges. We had seen the constitutional provision, Article 124 Clause 4 and Article 124 Clause 5. Article 124 Clause 4 talked about that how the resolution can be passed in the parliament, and the basically it deals with the manner and the grounds of removal of judges of the Supreme Court, which talks about misbehavior and incapacity. However, Article 124 Clause 5 gives the power to regulate the process to the Parliament, and accordingly the Parliament has passed the Judges Inquiry Act of 1968, which we had seen yesterday. The last part of our discussion was this. The Judges Inquiry Act says that a resolution to this effect can be introduced in either of the house, the Lok Sabha or the Rajya Sabha. If it is to be introduced in the Lok Sabha, it requires the support of at least 100 members of the Lok Sabha. If it is introduced in the Rajya Sabha, it requires at least the support of 50 members of the Rajya Sabha. Once it has been introduced and the presiding officer is satisfied with its introduction, then the presiding officer appoints a 3-member judicial committee, which is headed by one of the sitting judges of the Supreme Court. The second member is the sitting judge of the Supreme Court or the High Court, and the third member is an eminent jurist. It is this particular committee which investigates the misbehavior or incapacity and accordingly recommends to the presiding officer. It recommends to the presiding officer. In light of the recommendation given by the Judicial Committee, voting is done, and Article 124 Clause 4 says that it requires a special majority in both the houses, that is, majority of at least 2/3 members present and voting, and the majority of the total strength of the house. Once it is passed by both the houses, it goes to the president, and the president has to sign the order of removal in the same session in which it has been passed by the parliament. If the president signs the order of removal, the judge is removed. Clear? Till now, never ever it has so happened that a judge of the High Court or the Supreme Court has been removed. Yes, there was a case in which I think it was Judge Ramaswamy who was likely to be removed, but before the parliament could pass such a resolution, he was alleged of corruption, and there was a process that was initiated. It was likely to be passed by both the houses of the parliament, but before that he resigned. He resigned from the position. Clear? This Judges Inquiry Act, it was challenged in the Supreme Court on the grounds that with the establishment of the Judicial Committee, that is the 3-member committee that is there, it is taking away the power from the parliament, because it is the parliament who has the power to pass a resolution, and it is the parliament who has the power to do what? It is the parliament who has the power to regulate the procedure. The Judges Inquiry Act, with the establishment, because it dictates the establishment of a 3-member committee, it is mandatory for the presiding officer to do that. It's not a discretionary power that the presiding officer has. No, it is mandatory for the presiding officer to establish a 3-member committee. And that is the reason why this was challenged. It was challenged on the grounds that it is taking away this power from the Parliament. The Supreme Court, while looking at the constitutionality of the Act, decided that it is not taking away such a power. It upheld the constitutional validity of the Act, and it said it is not taking away the power, rather it is merely, it is the Parliament who is establishing the committee merely to ensure the legality of what it does in the House. That means if a judge is found guilty of misbehavior, only then he is to be removed. This was the reason why the Supreme Court upheld the constitutional validity of the Act. The Supreme Court further said that the whole process can be divided into two. The whole process can be divided into two. One is the political act and the second is the judicial act. What is the political act? All of the discretionary powers that are there in this whole process, it is a part of political act. Like introduction of a resolution, that is a discretionary act of the Parliament, of the members of the legislature. It is a discretionary act. Similarly, when we talk about the passage of it, it is a discretionary act, whether people vote in favor of removal or against it. It is a discretionary act. No one can be compelled to do that. Similarly, acceptance by the presiding officer, because presiding officer can reject the whole resolution, as we had yesterday discussed what Venkaiah Naidu did when Deepak Mishra, the Chief Justice of India, and a resolution was being introduced by the opposition to remove Deepak Mishra. So it is also a discretionary act. So the Supreme Court divided the whole process into two, some political acts and some judicial acts. What were the political acts? Political acts were those acts which were discretionary on the part of the Parliament, like introduction of resolution, acceptance by the presiding officer, passage of resolution. These were the discretionary acts. And judicial act. Now, the second was the judicial act. And what was the judicial act? When we talk about those which were not the part of discretionary, those were not discretionary to the House, like establishment of a committee. As the law says, the presiding officer shall, which means it is mandatory. So it's not a discretionary act. So establishment of a committee, or for that matter, signing the order of removal by the president, it is a judicial act. Why? Because it is not discretionary. Once it has been passed by the Parliament, the president has to sign the order of removal. There is no discretion involved there. So the process was divided into political acts and judicial act. Political acts being those acts which are discretionary, and judicial act being those which are not discretionary, like establishment of a 3-member committee and signing the order of removal by the president. Clear? So the whole process is this. The Supreme Court has upheld the constitutional validity of the Judges Inquiry Act. Understood this idea? Have you understood this? Write this down. The Supreme Court in the Subcommittee on Judicial Accountability versus the Union of India, 1992 case upheld the constitutional validity of the Judges Inquiry Act, stating that it merely regulates the power of the Parliament. It merely regulates the power of the Parliament in removing the judges of the Supreme Court, it does not take away the power. It does not take away the power. Therefore, it is constitutionally valid. Therefore, it is constitutionally valid. The court also divided the whole process into a political act and a judicial act, a political act and a judicial act. A political act is where the authority concerned is exercising discretionary powers. Otherwise, it is a judicial act. The introduction of resolution and the passage of resolution, is therefore a political act, and appointment of a three-member committee, investigation of charges by the committee, and the president passing the order of removal, are judicial acts. Clear? If you look at this very process, the process of removing a judge of the Supreme Court by the constitutional process that is mentioned, it has been mentioned in such a manner that it is not easy for the executive or the legislature to do what? To in any way remove a judge of the Supreme Court. This is also true for removal of judge of the high courts. The process that is there, it is similar, and hence it is difficult to remove the judge of the high court as well. Now, there is a question that comes up here, that is with respect to accountability of judges. Interestingly, if you look at the process, go back to the very first class that we had come up with, and we had discussed an idea called as separation of powers. And if you look at separation of power, the principle of separation of power dictates that these three bodies that are there, that is the executive, the legislature, the judiciary, they are going to have their own sphere of competence. So the power will not be concentrated in any one body. Which was previously the case, and this will prevent the state from being a tyrant or in any way encroaching upon the rights that the citizens shall have or does have. Clear? And if we look at the legislature and the executive, based on what we have discussed, we have already seen the Council of Ministers at the center level, the legislative, we have also discussed certain ideas about the legislature, and we know that there is effective control that is imposed on the legislature. There is some effective control that is imposed on the executive as well. And some control that is imposed on the legislature and the executive, it stems from the powers that are enjoyed by the judiciary, such as the power of judicial review. However, if we see what is dictated by the principle of checks and balances, if we see what is the principle, what is being dictated by the principle of checks and balances, what we see is that the Indian institutional setup, or how we actually implement separation of powers and checks and balances, we can say that the judiciary is not under the checks and balance principle that is there, that is very true for the executive and the legislature. Why is this the case? Why am I saying that the judiciary is not under checks and balances? Because if you look at through judicial review, not only is the executive under the check of the judiciary, the legislature is also under the check of the judiciary. Going back to fundamental rights, we have seen due process of law and all these things. Now we know these. So there is an effective mechanism. If legislature enacts a law, right now itself, just before I started the class, I was going through the news, and the Supreme Court has said that they are not going to impose any kind of restriction on the CAA, the Citizenship Amendment Act. However, if the Supreme Court wanted, and the Supreme Court declared this, that this is something that that is unconstitutional. So there is a valid check that any law that is being made by the legislature, can be checked upon by the judiciary. That is also the case for executive acts. Like last week itself, there was a decision of the court with respect to the restrictions that have been imposed in the state of Jammu and Kashmir, in now the UT of Jammu and Kashmir, that the internet is not working and all these things, and there was a decision of the court on it. The court said that the executive needs to come up with all the orders, make it transparent for everyone, so that if there is any problem that any individual has on the orders that have been passed by the executive, they can challenge it in the court. This was one aspect of its decision. So through this, what we can see, not only is the legislature, we have yesterday itself discussed about the NJAC, National Judicial Appointments Committee, and through declaring the NJC unconstitutional, the judiciary has exercised control over the legislature, the judiciary exercises control over the executive. But what about the control over judiciary? What about the control over judiciary? Because if you look at the judicial decisions, there is, effectively speaking, no control over the judiciary. Why? Who is basically taking up the appointment of judges? Traditionally or constitutionally, this is an act that should be taken up by the executive, the president. But is the president actually doing it? President is like a rubber stamp there. Whatever decisions are being made by the collegium, that is basically being stamped by the president. This is what the president does. Traditionally, this is not the case. If you compare this very setup to that of US, you will find that this is not the case in US. In US, the president can appoint any individual to being the judge of the Supreme Court. Last year itself, in 2019, there was a very big controversy that was there in US, because President Trump actually appointed an individual called as Justice Kavanaugh. He was one of the judges of the Supreme Court in the state. He was appointed to the Supreme Court of the federal court that is there. And while appointing him, there were number of criticism. Why? Because when he was named that he is going to be appointed, as I said, I've earlier also discussed, all the appointments that are made by the president there, they are subject to the agreement of the Senate. Senate will appoint a committee, they will investigate the individual and finally appoint that individual to that position. So when it was declared that he was to be appointed to that particular position, what happened was that there were a few cases of sexual harassment against him that came up. So there was a case in which one of his colleagues, when he was in college, he was in college, so she alleged that this individual had sexually harassed her in college. And there were two or three cases that came up. and that was scrutinized. That was scrutinized. All of it was done during the Senate hearing. He was questioned about it, etc., etc. But finally, the decision of the president to appoint him, it was what was carried out, and he was finally appointed as the judge of the Supreme Court there. In India, this does not happen. In India, this does not happen, and the president, we have already seen in the second judge case itself, Skara versus the Union of India case, the Supreme Court went on to say that because the process is to ensure that the best possible individual is appointed to this particular position, hence if there is a difference of opinion between the two constitutional authorities, the opinion of the judiciary expressed by the Chief Justice of India will be given primacy, and it will be binding on the president. So it is the judiciary who appoints judges. It is the judiciary who takes up judicial review. And when it comes to the power, if you look at, go to our previous discussion, Article 129 of the Constitution. What is Article 129 of the Constitution? Article 129 of the Constitution. 2-3 पेज पलटने से नहीं होगा. If you don't remember it, you will not remember where I have talked about it. What is Article 129? So important. What is Article 129? If you go back to discussion of Article 19 of the Constitution, we talked about something called as contempt of court. And Article 129, I had specifically discussed there that it is Article 129 which declares the Supreme Court as a court of record. And what is the meaning of court of record, I had explained there itself. So when it comes to judicial decisions are, if in any way, if they are not complied with, in that case, the individual can be punished for contempt of court. And what is the result of this? The result of this is that in India, not only is the separation of powers not properly implemented, because we have a parliamentary democracy, and in a parliamentary democracy, executive and legislature cannot be separated. Executive belongs from the legislature. So what we say, in a parliamentary democracy, separation of powers is only partially implemented. That is also when it comes to the principle of checks and balances. This is in India specific. Why? Because if we look at the judiciary exercises effective control. Judiciary exercises effective control over the executive, over the legislature. But judiciary is not under the control of the executive or the legislature. Why? Because any such laws that are enacted by the legislature, such as NJAC, is viewed as encroachment on the independence of the judiciary. It is viewed as an encroachment on the independence of the judiciary. And the judiciary frequently interferes with what the executive has to do, what the executive has to say. We have already seen Article 356 of the Constitution, imposing President's rule. Dekho, it is an executive act. It is an executive act. But through the SR Bommai case, the Supreme Court has imposed restrictions on it. Through the SR Bommai case, the Supreme Court has imposed restrictions on it. No, and all executive acts, all such executive acts are challenged in the court. So the Supreme Court exercises control over legislature and judiciary, the legislature and the executive. But the executive and the legislature does not enjoy effective control over the judiciary. The accountability of the judges. We are talking about accountability of the executive. It is absolutely fine. We are talking about the accountability of the legislature. Yes, it should be done. But that does not mean that the judiciary should not be accountable to any individual or any party. But today we live in an age wherein when we see the judiciary is it seems to be unaccountable to anything. There are so many examples that you can view here. And one of the very recent examples in this particular context, you can see this, you can see this in this very idea that when the Chief Justice of India is, it is alleged by one of the members of the court, there, that the Chief Justice of India has been sexually harassing her. There was a sexual harassment, idea that came up there, and the Chief Justice of India presided over the, over its hearings. When the Supreme Court was hearing this particular matter, the Chief Justice of India was participating in that hearing. It is a violation of natural justice. We have seen that. It is a violation of natural justice. But the judge is not under any kind of accountability. There is no such accountability of the court. There is no such accountability of the judge. When the Supreme Court comes out with decisions such as what it gave in the Sabrimala case, and finally again had to refer it to the higher constitutional bench. Now, what is the accountability of the decisions that are being done by the court? There is no such accountability. Forget about the decisions. What is the accountability of the judges when it comes to, suppose there is a case of corruption? We had yesterday itself discussed. There have been cases wherein previous Chief Justices of India have been alleged that they have been involved in a case of corruption. But there is no institution to check that, because if you look at the judicial institutions, institutions do not fall under any of this organization, such as they are not under effective control of the CBI, which is responsible for taking up investigation of cases of corruption. They are not under the CVC, the Central Vigilance Commission. They are not under the Lokpal, the new institution that we have created. They are not under the Lokpal as well. The judiciary has been kept outside the Lokpal. So what is the check that the judiciary has? Effectively speaking, there is no such check. In fact, there was a body that was conceived of. There was a body that was conceived of called as the National Judicial Council. It was conceived in the year 2009-2010. And it was being debated that by 2012 also we were seeing that it was likely to be created, a body called as the National Judicial Council. What was this body? The body comprised of the Chief Justice of India as the chairman of the council, and two senior most judges of the Supreme Court and two senior most Chief Justices of the High Court. So this would be a 5-member body presided over by the Chief Justice of India. Two senior most judges will be the 2 members, and 2 senior most Chief Justices of the High Courts will also be the member of this particular committee. And the responsibility of the council was what? To check judicial corruption. But this body has not been created. And effectively speaking, as of today, there is no such body that exists to actually check the activities or the corruption that is there in the judiciary. So accountability of this body is not necessarily there. Clear? Understood this idea? Now this is about basic accountability, and we live in an era of obviously judicial activism. Further, that creates that rule of the judiciary, not the rule of law, rather than rule of the judiciary is what we see with judicial activism. Judiciary tends to interfere everywhere. See, what is the difference between judicial review and judicial activism? When we say judicial activism is not backed by the constitution, what does that mean? Just because the term judicial review is also not mentioned in the constitution, so is the term judicial activism. It has also not been mentioned in the constitution. What is the technical difference between judicial activism and judicial review? Anyone? How can you define judicial review? First, let's come to judicial review. How can you define judicial review? How can you define judicial review? To check the constitutionality of the laws that are passed by the parliament and the acts of executive. When you compare these acts to ensure that they are constitutional in nature, that is what is judicial review. Now, while performing judicial review, the court only looks at the constitutionality of the act. That means sees the provisions of the law or the acts that have been taken up by the executive and compares it to the to the constitutional provisions, whether they are in line with the constitutional provisions or they are contradicting the constitutional provisions, and accordingly declares this is constitutional, this is not. In judicial activism, the court goes beyond this, and the court also declares what is the corrective measure or what should be taken up, by the executive or the legislature. Now, when the judiciary starts giving directions to the executive or the legislature, now this is not what you can say, traditionally speaking, it does not fall under their sphere of competence. They only interpret the law. They do not tell the executive and the legislature what is to be done. That does not fall under the purview, under the purview of the judiciary. That is something that is not to be done. Why? Because the judiciary is only responsible for reviewing, seeing whether the acts are constitutional or not deciding what is to be done by the executive and the legislature. So what is the difference between review and activism? Review is where the judiciary is only reviewing or looking at the constitutional validity of the act. When the judiciary goes beyond this idea and starts directing the executive and the legislature as to what should be done, that is what is judicial activism. Yes. See, if the directions are in the nature of orders, it is mandatory. If the directions are in the nature of orders, it becomes mandatory for the legislature and the executive to do what has been directed by the judiciary. If the act, if the when the court issues an order, it becomes mandatory. See, it is completely dependent upon the judiciary. It can be in the form of advice, like if we talk about things such as police reforms. The Supreme Court has in number of cases asked the state to take up police reforms, various states to take up police reforms, but they have not. That is not an order. That is not an order. If it is an order, it becomes mandatory for the executive to do that. It becomes mandatory for the executive to do that. So when we talk about activism, because there is no boundaries of activism, we cannot say this is something that falls under activism and this does not. Activism can be taken up by the judiciary as an order. You have to do this. Activism can also be in a different manner. It can be viewed in a different manner as well. What? The court directs but does not order. Does not order. That can also be a part of activism. Clear? Now, when we talk about activism, there is an instrument that has been included in the jurisprudence of India by the Supreme Court of India, which has been a primary mechanism to take up judicial activism. That is called as PIL, Public Interest Litigation. Public Interest Litigation is what? Public Interest Litigation, it is something that is it is practiced in the jurisprudence of US. There it is called as SAL, social action litigation. There it is called as social action litigation. PIL works on the basis of the maxim that is, or the principle that is used there is called as pro bono publico, which means in public interest. In public interest. So if you see the idea of judicial review, the idea of judicial review sees that constitutionality. You will look at the constitutionality of the act, and judicial review, the principle of judicial review dictates that this is something that will be what? This will be something that will never be sua motu, which means by itself. That means it will always be through a petition. If there is a petition that is being filed by any individual challenging the constitutional validity, only then the court will practice judicial review. But when we talk about the idea of judicial activism, now the idea of judicial activism here, which we have taken from US, it is not mentioned in the jurisprudence of India. When I say jurisprudence, it means the mechanism in which the judiciary works. In the jurisprudence of India, there is no such thing that has been mentioned such as a PIL. It has been included in the jurisprudence by the Supreme Court itself, by the judiciary itself. It has been integrated there. And through the PIL, what is the judicial conceptualization of it? That public interest is to be served. Public interest is to be served. Why? Because if you look at Article 142 of the Constitution, what does Article 142 of the Constitution dictate? To do complete justice. Clear? In the Ayodhya verdict, you have not read the Ayodhya verdict then, because in the Ayodhya verdict, the Supreme Court referred to Article 142 of the Constitution. Article 142 of the Constitution says that the Supreme Court is empowered to do complete justice. The Supreme Court is empowered to do complete justice. And whatever is necessary, that means any direction, any order, any decree that is to be passed by the court can pass it to fulfill what? Doing complete justice. In the power that has been given to the Supreme Court under Article 142 of the Constitution, evoking that particular power, the Supreme Court has done what? It has included an aspect or an idea in our jurisprudence called as the PIL. Here, what is the judiciary doing? The judiciary is exerting itself or acting more assertively. It is playing an assertive role for achieving what objective? So that the executive and the legislature fulfills their constitutional duty. They fulfill their constitutional duty. What is the objective of pro bono publico? The maxim, what does it dictate? In public interest. So ensuring that the court is taking up all necessary actions, passing any order, direction, decree to ensure that complete justice is done. That is achieving public interest. By evoking what is mentioned under Article 142 of the Constitution, what is the Supreme Court doing? Or no, what is the, in fact, that can also be done by the high courts, because writ jurisdiction, remember. So they, through writ jurisdiction, they have the power of judicial review. And through judicial review, they have derived the power of judicial activism. What is the court trying to do? The court is trying to do complete justice. And because of this, the Supreme Court has come out with something called as PIL. Now in PIL, what happens? Any individual can file for a PIL directly to the Supreme Court or to the High Court. Not in the subordinate court, because remember, subordinate courts do not enjoy the power of judicial review. We have already talked about it. It is only the High Court and the Supreme Court which enjoys the power of judicial review. And that is the reason why only the High Court and the Supreme Court can entertain a PIL. Only these two courts can entertain a PIL, it cannot be entertained by a subordinate court. ठीक है, इसीलिए एक मूवी थी जॉली LLB, उसमें PIL सबऑर्डिनेट कोर्ट एंटरटेन कर रहा था. बिल्कुल गलत है, फैक्चुअली इनकरेक्ट. कैनॉट बी डन. ठीक है, इट कैनॉट बी डन, इट कैनॉट बी टेकन अप बाय द सबऑर्डिनेट कोर्ट. Now in this case, through the PIL, the Supreme Court has taken up this idea of judicial activism, and the High Court, they have taken up the idea of judicial activism. See, there are two things that you need to understand here. The first is the positives associated with judicial activism. The positives that are associated with judicial activism can also be seen in the manner as the purpose that has been served by the PIL. What has the PIL done? The PIL has expanded the scope of fundamental rights. Most of the decisions that the court you see, the court gives with respect to fundamental rights, it is done on a PIL that has been filed in the court. It is done on this very basis, a PIL that is filed in the court. So, Section 377, last year there was a decision of the court, Section 377, in fact, exactly 1 year ago, in the month of January, February itself, the court came out with the decision on Section 377 of IPC, wherein it said that homosexuality cannot be considered as unnatural sex. And included what? Included, while it started hearing this matter on 377, it did what? It included one of the fundamental rights. It said that choosing a partner is a part of an individual's fundamental right to life. Expanded the scope of how we conceive fundamental rights. How we conceive fundamental rights. So through judicial activism and through the mechanism of PIL, what has the Supreme Court done? The Supreme Court has provided, or the one and the most important purpose that it has served is, it has expanded the scope and ambit of fundamental rights. Second, providing an environmental friendly administration. There have been number of cases in which the Supreme Court, taking up this view of environment, have directed the executive not to perform certain acts. Example, I'll give you an example. Around 2 or 3 years ago, there was a program that was organized in the banks of Yamuna. In the banks of Yamuna, it was organized by this organization, Art of Living. Yes, the Shri Ravi Shankar, who has this organization, the Art of Living. in this case, when he organized this particular program, when the court heard the matter, because it was said that the banks of Yamuna is as it is environmentally very sensitive, and this program can cause a permanent ecological damage. Despite all this, the program was organized, and then it was directed by the court to do what? For Shri Ravi Shankar to pay a ecological damage fee to the government. He claimed that he did not have money, and he requires the time so that he will take take up fees and then give it to the government. But the Supreme Court did that. Complete justice, and environment friendly administration. There have been number of cases in Goa also, where on the beaches, there were number of township programs that had come up on the beaches of Goa. And it was the Supreme Court has completely said no, it cannot be done. It is going to lead to an permanent ecological damage to that particular beach. An environment friendly administration. A corruption free administration. Number of cases against administration in regard to this very idea of corruption. And it has raised awareness among the citizens with respect to their rights. With respect to their rights. Like in the J&K verdict, the court talking about internet as a mechanism which is used to express your freedom of speech and expression. In fact, there was a case in the Kerala High Court, and in that Kerala High Court, if you have read the newspaper, you must have come across this. The internet was also declared as a fundamental right of an individual. It was declared. So what is the court trying to do? Raising awareness among the people about their fundamental and other rights, not just fundamental rights but also other rights. Clear? So this is the objective that the Supreme Court and the High Court have fulfilled when they have taken up this mechanism of PIL, or when they have done what? When they have practiced this idea of judicial activism. But judicial activism is not always only good, because yes, it has the fundamental objective of ensuring that the executive and the legislature perform their constitutional duties. Hence, obviously, it is important, and accordingly it is being done. But what is also important is that if you look at the flip side of judicial activism, that is the negative side of judicial activism. Through judicial activism, court has entered into a field which traditionally does not belong to that particular organization. The separation of powers. There is a complete violation of separation of powers if the court frequently performs judicial activism. See, once, twice, it is fine, because the executive and the legislature, if they are not fulfilling their constitutional duties and the court comes up with an idea or comes up with something to ensure this, it is fine. But regular practice of this, what does that lead to? That leads to judicial adventurism. Judicial activism turns into judicial adventurism. Why? Because through this, the judiciary is entering into a field. Judiciary is entering into a field which traditionally does not belong to him, to this particular institution. And this does what? Sometimes the judiciary takes up an act like directing the administration to do something. But the problem is, how can you direct the administration to do something when you yourself do not have an administrative sense? Judiciary has the judicial sense, legal sense. उनको लॉ के बारे में पता है. but they do not have administrative sense. They do not have administrative sense. When you are directing the executive to do something in the state of J&K, now if suppose because of it there is loss of life that happens there, who is responsible for it? And how can you definitively say that while coming out with some directions, if they take up certain directions, it will not result into something that will be negative for this particular part of India? It is something that if practiced in long term, it turns into judicial adventurism. And this has the what you can say capability to destroy separation of powers. It has the capability to destroy separation of powers. Not only does judicial adventurism have the capability to destroy separation of powers. This is something that has been understood by the court itself, and the Supreme Court itself has directed the other courts, the high courts, and directed upon itself that while taking up judicial activism, you should ensure that it is practiced sparingly, not very frequently. It should be practiced sparingly. It should not be practiced frequently. Why? Because if practiced frequently, it has the potential to destroy separation of powers. If you see the mechanism of PIL, one of the problems that is associated with PIL is it has choked the judicial mechanism. The judicial machinery that is there, it has been choked because of PIL. Why? Because the court has, because the Supreme Court and the High Court are regularly receiving and hearing such PIL, the normal judicial process that is there, it has become a burden on the judiciary. It has become a burden on the judiciary. And that is the reason why when it comes to civil cases and when it comes to criminal cases, when it comes to civil cases, it takes a court to hear that matter and completely dispose that matter. Coming from subordinate court to the Supreme Court, it might take more than 40-50 years for a civil case to be completely disposed of. And this does what? This very practice defeats the purpose of justice. So when you are talking about complete justice, don't forget that if you are denying justice or if you are delaying justice, that is also denial of justice, which means it is your responsibility to do complete justice. And your responsibility to do complete justice also includes that you hear matters promptly and decide it promptly, so that justice is not delayed. And even cases such as, even so much highlighted cases such as, what happened in the Nirbhaya case, it took us 7 years. In fact, more than 7 years. It has taken us more than 7 years to actually complete the whole process. So subordinate court, high court, Supreme Court. And in this, the process that is there, it has been choked by the PIL. The system that is there of PIL. And that is the reason why the Supreme Court has come up with certain directives how they are actually going to listen to PILs. Directives such as, they have first of all come out with a procedure called as they have actually taken the help of, they have created an organization, an informal idea called as the amicus curiae. What is meaning of amicus curiae? It means friends of court. It means friends of court. And what is the responsibility of these amicus curiae? They are the ones who investigate when a PIL is filed, whether there is a prima facie case or not. So the court takes the help of amicus curiae, friends of court, to investigate whenever a PIL is filed. PIL, public interest litigation, not private interest litigation. It is public interest litigation, to ensure that there is a prima facie case wherein public interest is involved. There the court has taken the help of something called as amicus curiae. Secondly, it is also to be seen. What is to be seen? Whether if a PIL is found to be frivolous in nature, the court imposes penalty. The court imposes penalty on individual or organization which has filed the PIL. The court has come out with a check on PILs. So the court does what? It first of all, if it finds that the PIL is not important, it is frivolous in nature, in that case the court imposes extraordinary penalties. Very recently, if you have going through the newspapers in the last 6 months itself, there has been a case in which an individual was fined 10 lakhs for filing a frivolous PIL, for wasting the time of the court. He was fined 10 lakhs. Similarly, if the court finds that there is a PIL which is worth looking into, then the court refers the PIL to amicus curiae, seeing the friends of the court, seeing they are responsible for prima facie investigation. Okay, is there a matter that should be heard by the court? If the court finds that yes, there is a matter, only then it hears it, otherwise it does not. Clear? This is the two checks, like the Supreme Court has included this in its procedure. To ensure that there is the choking of the judicial system that we are talking about. This choking of the judicial system to a certain extent is taken care of. Understood this? Have you understood this? This is the whole idea of PIL, judicial activism. There is also a term that you will read in the newspapers, judicial encroachment or overreach. See, what is the difference? What is judicial review? When you look at the constitutionality, when the court looks at the constitutionalities of an act. What is judicial activism? When judiciary directs the executive or legislature to do something. And what is judicial overreach? When the judiciary itself performs an act which belongs to the executive or the legislature. Like in 2015, the Allahabad High Court appointed Lok Ayukt of that particular state. Lok Ayukt, do you understand who is a Lok Ayukt? So Lokpal is an institution at the union level, and at every state there is an institution called as a body that is created called as Lok Ayukt, responsible for checking corruption at the state level. Lok Ayukt. And when frequent directions given by the Allahabad High Court, when the executive, that is when the Akhilesh Yadav government was there, when they failed to appoint a Lok Ayukt, in one of the days, the Allahabad High Court themselves appointed the Lok Ayukt. Now this job is generally, it belongs to the executive, not to the judiciary. But when the judiciary performs this job, it is called as judicial overreach. Clear? Understood this idea? So this is what is PIL. This is what is judicial adventurism or judicial activism, all of this idea. See, remember what I have talked about here, it is an evolving idea. So don't write and learn this. That is the reason why I don't dictate this idea as to what is judicial adventurism, because then you will not take the pain to actually go through the newspapers and then write it by yourself. Write this idea of, understand this PIL, judicial activism, understand this and write it by yourself. And whenever you are writing this in your examination, simply writing what I have discussed will not suffice. You will have to write good examples, and that examples you will give how? Not by, suppose you read Lakshmikant, there is a topic called PIL there, and you will find that it has, there are number of things that have been mentioned there, but you have to give current examples. Whatever you read in the newspaper, now you give that example, now that becomes more substantive. Clear? So this is this very idea. Now we come to some factual aspects of our discussion, starting with Article 127 of the Constitution. To a certain extent, there have been number of examples for this. There are number of examples. In cases of corruption, the example is this. The Rafale case. The Rafale case was heard by the court. What was the ground for hearing the Rafale case? This was the very ground, that corruption, the opposition party had claimed that there has been a case of corruption. Because they claimed this, so it was referred to the court. The court heard it. It was a closed hearing. There was, the court directed the government, you should submit in a closed envelope the details of Rafale. They submitted that. Court said there is no case of corruption. There is no case of corruption. Very recently, I think it is 2 months ago or something like that, the court has dismissed that petition. It is an example. It is an example. Clear? Article 127, that is appointment of ad hoc judges to the Supreme Court. Appointment of ad hoc judges to the Supreme Court. Clause 1. Clause 1. If at any time there should not be a quorum of judges, of the Supreme Court, available to hold or continue any session of the court, the Chief Justice of India, with the prior consent of the President, and after consultation with the Chief Justice of High Court concerned, request in writing of the court as an ad hoc judge, of judges of high courts duly qualified, for appointment as judge of the Supreme Court. Clause 2. The judge designated as ad hoc judges while attending will have all the jurisdiction, power and privileges and discharge the duties of a judge of the Supreme Court. Clear? Next, Article 128. See, Article 127 deals with ad hoc judges. So suppose there is a number of judges, like yesterday we discussed one Chief Justice of India and 33 peonage judges. So there are 34 judges that are there. So suppose these judges are hearing certain matters, and because of whatever reasons they are unable to attend the court, and the Chief Justice feels that to discharge the responsibilities the court requires a certain number of judges. So during this particular time, with the previous consent of the President and with consultation of the High Court concerned, will appoint some individuals of the High Courts, who are acting as judges of the High Courts. They can, for a brief period, for a temporary period, they can be the ones who will be hearing, who will be acting as judges of the Supreme Court, and they will be hearing matters in the Supreme Court. Only those judges who have the necessary qualification to be appointed as the judge of the Supreme Court, they can be appointed. And when they are appointed as an ad hoc judge to the Supreme Court, they will have all necessary powers and privileges that are enjoyed by the judge of the Supreme Court. Clear? Next. Quorum means any necessary number of judges. No, it's not fixed. As you have seen, when the Chief Justice feels the quorum means minimum number of judges that are required, but there are no fixed period. Next, Article 128, attendance of retired judges. Attendance of retired judges at sittings of the Supreme Court. At sittings of the Supreme Court. The Chief Justice of India, with the previous consent of the President, may request any person who has held the office of judge of the Supreme Court, or the judge of the High Court, duly qualified to be appointed as the judge of the Supreme Court, to sit and act as the judge of the Supreme Court, Such a person is entitled to allowances and privileges as the President may by order determine. Clear? Next, Article 131. Original jurisdiction of the Supreme Court. What is meant by original jurisdiction? Have you heard about this term? Yes.
Hearing a case for the first time.
Yes, exactly. Original jurisdiction means the jurisdiction with respect to those matters which can be heard only by the Supreme Court or can be heard by the Supreme Court for the first time, which means it has not been heard in the subordinate court, it has not been heard in the high courts, it is directly being appealed in the Supreme Court. Clear? What are those original jurisdiction of the court? You can write this. What is meant by original jurisdiction? It means the jurisdiction of the Supreme Court the jurisdiction of the Supreme Court to hear a matter for the first time. For the first time. They are first, disputes between the Government of India, between the between the Government of India on one side and between a government of state or states on the other side. Between the Government of India and government of state or states at one side and between the government of states at the other side. So between the government of state on one side, or there may be a group of states, versus between a state or a group of state. Clear? Now, based on our previous discussion, there are 2 or 3 things that you need to understand here. The exemptions. That means what are certain disputes which might fall under this very category, but does not fall under the original jurisdiction of the Supreme Court. Based on our previous discussion, have we discussed any of such thing? Water disputes, very important. First exemption here you can see under Article 262, which deals with interstate water disputes, sharing of waters, etc., etc. Anything else? What we have discussed, from what we have, I am asking you from what we have discussed. Any exemptions that you see? नहीं, बिल्कुल नहीं. कश्मीर का नाम मत लो. Under Article 279A. Under Article 279A. What was 279A? Yes, GST Council. So what was the provision there? Dispute of the GST Council, how it is to be resolved? By a mechanism decided by the GST Council. So it may so happen that that dispute is kept outside this. Under Article 280, which deals with what? Recommendations of Finance Commission. Recommendations of Finance Commission. Clear? Recommendations of Finance Commission. So river disputes are there under Article 262. Matters that are referred to the Finance Commission, that is also there. Clear? One more thing you can write here. 4th point. Write this. If any treaty, agreement or other similar instruments, treaty, agreement or other similar instruments entered into or executed before the commencement of the Constitution, the dispute involving interpretation is the exclusive discretion of the executive. Exclusive discretion of the executive before the Constitution. See, there was a treaty called as Kaveri Water Treaty that was done in the 1800s itself, and I think again in the last 4 years when the state of it was, I think, the state of Karnataka which disagreed to give water to the state of Tamil Nadu, it was now the jurisdiction of whom? The executive, not the Supreme Court. And the last point you can write, adjustment of certain expenses, adjustment of certain expenses between the union and states, between the union and state. Clear? Next, Article 132. 132, appellate jurisdiction of the Supreme Court. Appellate, A-P-P-E-L-L-A-T-E, appellate. What is the meaning of the term appellate? Appeal. So when it is something that has originated in some lower court and is transferred to the Supreme Court as a matter of appeal, that is what is appellate jurisdiction. See, this is a very important prelims question. Which of the following is appellate jurisdiction? Which of the following is original jurisdiction? Very important prelims question. If you see your previous year papers, you will find that in the last 5 years, at least it has been asked 3 or 4 times. Appellate jurisdiction. What is appellate jurisdiction? Anything that comes to the court in a matter of appeal. In a matter of appeal. So it has been heard by some other court. Now it goes to the Supreme Court in the form of an appeal. Clear? What is an appellate jurisdiction? Now, what is that? Right, first point. Any matter, civil, criminal or other, which requires interpretation of the Constitution. Interpretation of the Constitution. So constitutional, whenever we talk about this power of judicial review or constitutionality of a law or any act, whether it is civil or for that matter it is criminal or any other matter, it is a part of appellate jurisdiction, not original jurisdiction. Constitutional matters do not fall under the original jurisdiction of the court. It falls under the appellate jurisdiction of the court, not the original jurisdiction, because high courts have writ jurisdiction, and when high courts have writ jurisdiction, they also have the power of judicial review. So they can interpret the Constitution as well. Clear? Second, where such a certificate is given, any party in the case may appeal to the Supreme Court on the grounds that any question as aforesaid has been wrongly decided. In brackets write civil, criminal or others. Which means, simply speaking, it means if I am not happy with the decision of any court, subordinate court, I go to the high court, I go to the Supreme Court. So when it comes to the Supreme Court has all jurisdiction with respect to every other matter that is mentioned in either it is a civil matter or it is a criminal matter, or for that matter it is any other matter that is there. It has appellate jurisdiction. You cannot say that the decision of the High Court is final in this regard. No, it is the jurisdiction of the Supreme Court, which is always final, not the decision of the High Court. Clear? And the one more thing you can add here: appeal for special exemptions. Special exemptions. See, special exemptions simply means that at any given point of time, it may so happen that when I am not ready to serve a sentence, if suppose I have been awarded a sentence by any court, I can always appeal in the court for giving me some special concession on that matter, that I will be able to serve the sentence suppose after 6 months, not today. Why? Because I have to get some things sorted out. So I might have an individual who is dependent on me. So to take care of that individual, I might need some time to make some necessary arrangements for it. So, if individual is dependent on me, like suppose my parents who are not any more able to move or something like that, they are dependent on me. So I will appeal in the court that please give me some special concession. I am ready to serve this sentence, but after 6 months because of this matter. In that also it can be appealed in the court. Clear? It is a part of appellate jurisdiction of the court. Clear? It is called as special leaves. It is called as special leave. And in bracket you can write Article 136. Article 136. Article 136 gives that special leave. Next, Article 137. 137. You can write this. Subject to the law made by the Parliament, the Supreme Court, law made by the Parliament, the Supreme Court shall have the power to review, its own judgment, orders and pronouncements. So Supreme Court has the power to review its own judgments, orders, anything like that. Now, have you in the last 2 weeks in the newspaper, have you read about something called as a curative petition? In what context? Two convicts had filed for a curative petition. What is curative petition? Any left out case. What is meant by left out case? Any left out condition in a particular case. To a certain extent you are correct. Curative petition means so that the court is able to discharge its duties without any error. The court has allowed for something called as a curative petition. That means when an individual has exhausted all his petitions that he can file, he can still go for the last resort, that is called as a curative petition. In the curative petition, the court will ensure that there is no mechanism or no shred of doubt about the individual's involvement, so that when he is being punished not out of an error made by the court. Clear? That is what is called as a curative petition. It is the last resort. It is the last resort when everything has been exhausted. Because see, if you can go to the subordinate court, after that you go to the High Court, after that you go to the Supreme Court. And in the Supreme Court you have 2 or 3 appeals. Once the court decides your matter, again you can appeal in the court. You can, after the decisions of the court, you can go to the you can file for a petition, pardon petition for the president. If the president denies, finally the last thing that is done is you can appeal as a curative petition to the court. The court, while hearing your curative petition, will ensure that there is no shred of doubt or no, what you can say, error that has been made. Clear? And that is the last petition. Once an individual files for a curative petition, that's it. उसके अलावा फिर कुछ नहीं होता. That is why the two convicts filed for a curative petition. Clear? The two convicts filed for a curative petition, and in fact in the last 2-3 days itself, one final petition was filed by one of the convicts. It was thrown out of the court. The court did not even hear the matter. The judge threw the petition out of the court, saying that no more hearing on this particular case. Curative petition is the last resort. Clear? Write this, curative petition. According to me, this is a question that is due. It can be asked, whether it is your prelims examination or it is your mains examination. In exercise of its curative petition, in exercise of its wide powers, the Supreme Court has also coined wide powers. The Supreme Court has also coined the remedy of curative petition. The remedy of curative petition as part 3 of the Constitution guarantees every individual fundamental rights, and the constitutional bench in Rupa Ashok Hura versus Ashok Hura case denied the claim of questioning the validity of a final order or judgment of the court under Article 32. However, it suggested that a curative petition could be filed against any final order or judgment of the court if it is observed by the court that there has been denial of or non-observation of natural justice or on account of abuse of the process of the court. The curative petition cannot be allowed merely for reappreciation of evidence. Clear? Reappreciation of evidence. Remember this is a very important idea. Reappreciation of evidence means the court will not look into evidence. The court will only look into the procedure, that is it so that there has been an abuse of the process or natural justice has not been followed. in that case the court might dismiss the charges, because natural justice, it is very important. We have already seen natural justice is a part of Article 21 of the Constitution, the fundamental right that is there. So only on these grounds curative petition can be filed. It's a last resort, that for in any case if the individual can prove that this has not been followed, then curative petition can be filed. Yes. So, because natural justice belongs to all of these, no? Yes, it can be filed. Curative petition can be filed. An individual can file for curative, but acceptance of that is again dependent upon the court, whether the court feels that the natural justice has been followed or not, because interpretation will always be dependent upon it. So it will, in that case, it might even go for this, that yes, it has been followed. So it might reject the petition also. See, in case of constitutional validity of the laws, curative petition does not stand. Curative petition is generally in civil and criminal charges. That if there is a civil charge, or if there is more appropriately a criminal charge, because natural justice is in question there. Clear? So this is about the court's power to review its decision. Who has the power to review Supreme Court's decision? The Supreme Court itself. And how does the Supreme Court do that? See, what you have written is this. Underline the very first line that you have written under Article 137. What is it? Subject to the power of or law made by the Parliament, which means it may so happen that review petition or the Supreme Court reviewing its decision, it is subject to a law made by the Parliament, which means in certain cases it may so happen that a law is made by the Parliament and the law denies that particular power to the court. That can also happen. Technically speaking, because the Supreme Court has come out with basic structure principles, so obviously it is not possible. But otherwise, technically speaking, in that case, this power is there. And so that the Supreme Court does not in any way, the complete justice is done, to review its own decisions, there can be a curative petition that can be filed. We have already seen that now. Clear? Next, Article 139. Article 139. The Parliament may by law confer on the Supreme Court power to issue the power to issue directions, orders or writs, including writs mentioned under Article 32, or any of them for any purpose other than protection of fundamental rights. See, Article 139 is important for two purposes. First, here the Parliament may, through a law, give the power to issue additional writs to the Supreme Court. Those writs which are not mentioned under Article 32. First thing is that. The second is that the power to issue writs right now, as per our discussion, we know the Supreme Court issues writs only for protection of fundamental rights. But through a law, the Supreme Court can be empowered to issue writs for other cases also, not just always protection of fundamental rights. Clear? Next, Article 139A. 139A, added by the 42nd Constitutional Amendment. 42nd Constitutional Amendment in 1976, where cases pending before the Supreme Court, comma, or the High Court, or two or more high courts, or on a application made by the Attorney General of India, or on an application by any party where the Supreme Court deems fit, can transfer a case upon itself, or to any other high court, if the case is pending before a high court. Simply, it means transfer of cases. If the Supreme Court deems necessary, the Supreme Court can transfer a case that is pending before a high court upon itself. Or if the Supreme Court feels necessary, in that case, a case that is pending before one high court can be transferred to some other high court. Because of some reasons, like you will find that because of some political influence. I'll give you an example. In fact, there are number of examples here, like an example of the case in which Jayalalitha was questioned on the assets, income that she had. So it was transferred from Tamil Nadu to the state of Karnataka. Why? Because it was feared that she will have political influence there. Similarly, in a case that has happened very recently, one of the rape cases that happened in UP, because an MLA was involved, so the case was transferred from the High Court, Allahabad High Court, to another High Court. This power is there with the Supreme Court. The Supreme Court can do that. Clear? Next, Article 142. The Supreme Court, in exercise of its jurisdiction, may pass any such decree, order as it is necessary to do complete justice in any case or cause or matter pending before it. Such a decree or order is enforceable throughout the territory of India, in such a manner as may be prescribed by any law made by the Parliament, or in a manner as the President may order. Next, Article 143. Power of the Parliament to consult the Supreme Court. That is the advisory jurisdiction. The President in public interest at a time if it appears that a question of law or fact has arisen or is likely to arise or is likely to arise can obtain the opinion of the Supreme Court upon it. Can obtain the opinion of the Supreme Court upon it by referring the matter to the court. Next paragraph, write this. In cases or disputes arising out of a pre-constitutional matter, treaty or similar instruments, when referred to the Supreme Court by the President, the Supreme Court shall report to the President its opinion. Underline shall. In matters that are post-constitutional in nature, on being referred to the Supreme Court by the President, the Supreme Court may report to the President its opinion. Underline may. And in the next paragraph, write such an opinion referred by the such an opinion presented by the, don't write referred, presented by the Supreme Court is not an order or decree issued by the court, therefore is not binding on the President. Clear? Understood this? This is the advisory jurisdiction of the court, Article 143 of the Constitution. You have underlined things such as may. You have also underlined shall. What is the meaning of that may and shall? Yes? Shall is mandatory and may matlab it's not mandatory, it's optional. So for any pre-constitutional matter, it is mandatory for the court to express its opinion. The court cannot deny. But in post-constitutional matters, the court can deny expressing its opinion, and any opinion the court expresses, it is not binding on the President, as the jurisdiction is advisory. Clear? So with this we have completed all the important provisions with respect to the Supreme Court of India. So if we look at the jurisdiction of the court has some original jurisdiction, the court has some appellate jurisdiction, the court has some advisory jurisdiction also. The court also has writ jurisdiction under, the Supreme Court has writ jurisdiction under Article 32 of the Constitution. Is the writ jurisdiction an original jurisdiction of the Supreme Court? Is the writ jurisdiction an original jurisdiction of the Supreme Court? No. Why? So why is it not an original jurisdiction? We can directly go to the court for this. The High Court also has the power to hear it. See, the best way to define this is, it's a bit confusing here because you can go to the Supreme Court, you can go to the High Court as well. The best way to define this is in this manner. Whenever we talk about writ jurisdiction of the Supreme Court, writ jurisdiction of the Supreme Court is its original jurisdiction but not its exclusive jurisdiction. It's not its exclusive jurisdiction, because if you look at what we have talked about in original jurisdiction, we say that it hears the matter for the first time. Not only does it hear the matter for the first time, such matters cannot be appealed in any lower court. Any original jurisdiction that the Supreme Court has, that original jurisdiction cannot be appealed in the High Court. So High Court cannot take up a dispute between the Government of India or the Government of State. In such matters, the High Court cannot, they do not have the jurisdiction over such matters. But in writ jurisdiction, they do have writ jurisdiction. So what we say is writ jurisdiction of the Supreme Court, or writ jurisdiction, while we are describing the writ jurisdiction of the Supreme Court, we say it is an original jurisdiction but not an exclusive jurisdiction, which means even the High Court has the power to hear that particular matter. Clear? Understood this? With this, we complete our discussion on the the Supreme Court. Next, we take up High Courts. High Courts. See, in High Court, basically, most of the things are very similar to the discussion of Supreme Court. So we are just going to see, we are going to come to article wise, because in terms of some discussion with all the discussion that was required, we have already done that in the Supreme Court. So we are only going to deal with articles, and then we are going to come to subordinate courts. Clear? So let's start with High Courts. The first is Article 215. Article 215.
215.
Yes, 215. Because 250 is what? In case of? Yes, absolutely correct. सिर्फ एक ही इंडिविजुअल है पूरे क्लास में जो कुछ भी याद करके आता है. I'm telling you this. There is only one individual in this class who actually answers to the question that I ask. Only one. So see, you are going to compete with her. How do you how will you is this logical that when she is revising and when you are not revising, you will perform better than her? Is it possible? देखो logical, अंतरात्मा की आवाज से बताओ. It's not possible. You have to learn these articles. Actually, tomorrow will be the last day for our constitution. We have completed our discussion on only miscellaneous provisions are being actually, I am taking up that. In fact, if you go through the previous discussions, the last time that I took up polity, I even did not discuss High Courts. I don't discuss these things. The manner in which I have taught you, it is basically the most elaborative discussion of the Constitution of India that you will find anywhere. Anywhere. See, leave aside what is written in Lakshmikant. Leave aside that. Because in Lakshmikant, that is a book. So for that book, obviously, if I present a book to you which is only 100 pages of the Constitution of India, you will not believe that it is worth buying. So they have included that 1000-page book. But I'm telling you, whatever discussions we have had in the class, if you read this much of polity, I guarantee you are going to, you are able to answer all the questions that appear from polity. It's my guarantee. And you can do this by just going through previous year question papers. Don't believe in what I am trying to say. Just go through previous year question papers and try and see. Try and see that, what are the discussions that we have had. And just see all prelims questions that are there, it will be solved. That is from polity. I have not taken up governance yet. So obviously there are some topics that will be left out. But from the Constitution of India, all the questions that are there, you just try and go through those questions. It will all be solved there. There will not even be one question which you cannot solve. And if you cannot solve that question, no one will be able to solve that question. So you don't have to worry about such questions, because you have to be in that list 12,000 while qualifying prelims. Now in the first 12,000, if you are in the first 12,000, that's it. So when you are comparing how your performance is, you are going to compare in that particular manner. And if you see, out of the 15 questions that will be asked, if you are answering 14 of them, I am guaranteeing you all the 14 questions will be from what you have discussed. I don't take up, I don't discuss high courts, etc. But I am discussing that as well, just the constitutional aspect of it, so that you are absolutely comfortable. देखो, actually में तो classes हो चुकी हैं. Yes, things such as Comptroller and Auditor General, etc. There are one or two peripheral miscellaneous provisions that I have to discuss. Otherwise, I have discussed the Constitution. I have discussed the Constitution, each and every aspect of the Constitution. I have discussed it. If you don't start revising now, when will you start revising then? The topic is over. ठीक है, आप मतलब अभी भी वो स्वप्न में हो, सपना कहते हैं उसे. You are feeling that this is going to go on. No, it's over. We are going to start with another topic from Monday. This is over. Constitution of India is over. And till now, when I ask some very basic questions, I don't get a reply. Some very basic questions I am asking. I am asking you what is Article 250. And if you just go through your notes, you will find that I have discussed this Article 250 of the Constitution at least 3 times. I remember the date also. But वो बेइज्जती हो जाएगी आपकी. I remember the date on which I have discussed this. See, anything that when I am giving so much importance on it, when I have discussed why Supreme Court is called as Court of Record twice, why will you not learn it? When I have discussed it twice, it means it is more important. As it is, when we prepare for UPSC, we are not preparing the Constitution of India. We are just preparing the important parts of it. And as it is, whatever articles we have discussed in the class, all of them are important. And when I discuss a certain article twice, which means it is more important, and you should have learned it by now. But that is what I don't find. And that is the basic problem, with preparation. That is the basic problem. You don't consider the process to be as important as the result. You are thinking about the result, you are not thinking about the process. The process is as important as the result. Unless you work hard in this process, how will you get that result? How will you get that result? Just think of it. How will you get that result when you don't believe in the process? So if you have joined here, I am discussing all the provisions here. The kind of effort that is required to take a 2.5 hour class. Just think of it. Standing and speaking. I tend to, by now you know the way I teach. And in the last somewhere around 2 months, you would not have seen me even sitting in the class. Kabhi मैं बैठ जाता हूँ. That is too when I am very tired. Otherwise, I don't sit in the class. I ensure that each and every, even the individual who is sitting at the last, they are not left out. The kind of effort that is required. And if you don't work hard, it is basically defeating the whole purpose. We are not here for ourselves. I am telling you that. We are here for you. And in this particular time, I have to remind you, see, this is something that appeared in the newspaper. Actually, it should be the other way around. If I am not talking about the curative petition, after the class, you should have reminded me, sir, what is curative petition? Because now I don't read the newspaper at that length. Only those things that are important for me. That is what I see. Those things that are important for my class. That is what I see. So when I know that this is something that is important, you should automatically come to that. Curative, I have not talked about any such thing, curative petition, before today. But it appeared in an article that appeared last week. And you have not asked me this question. What is curative petition? So this is what I said in the very first day. If you remember, I talked about two ways of preparing for UPSC. One was being proactive and the other was having a laid back preparation. That laid back preparation, through that laid back preparation, you will always be one step behind what UPSC is. Until unless you have a proactive way to prepare. One step behind. You will always be one step behind. So when you see the question, you will feel, okay, I read it somewhere, but you don't know the answer. Or even if you know the answer, you might commit a certain mistake, either in factual or for that matter in understanding. This is the result of a laid back preparation. I'm telling you, this is the result of a laid back preparation. I have seen so many. The current pattern of examination does not allow you this kind of what you can say leniency, that you will you'll be laid back and you will prepare whatever is mentioned in your books and whatever you are going through and that will be it. No, you have to be proactive. If you are not proactive, it is very likely that this becomes a problem. And from day one, if you are not having that kind of energy to actually go through the newspaper, read the newspaper, connect it to what you are reading in the class, you are not going to develop it later on. I am telling you this, you are not going to develop this later on. You are either going to develop it today or no, you are not going to develop it at all. You should be, you should always be in that particular mode of preparation until unless you get that knack, until unless that you will not be able to crack this examination. See, there are, you are only 40 of you are here. There are so many other individuals who will also appear with you. They have also prepared. Some of them, you will maybe appearing for the first time. Some of them are appearing for the 6th time, the 7th time. Just think about the kind of knowledge they will have on Lakshmikant. ठीक है, उन्होंने तो पूरा पेज नंबर भी याद किया है, आपने तो फैक्ट्स पढ़ा है. They have remembered the page number also. They know all about. They will not make mistakes in prelims examination. They will not make mistakes. You will, until unless you ensure that you don't. Until unless you ensure that you don't. The whole of your syllabus, the whole of this, this classes that is there, it is designed in a certain manner. Saturday you have an off, Sunday you have a test. See, if what we can do is we can hold classes on Saturdays and Sundays also. What will it do? It will ensure that at least 2 months time, that that actually if it takes you 1 year or 9 months, so it will take you only 7 months to complete the whole syllabus, because you have 2 classes a day. So it will only take you 7 months to complete the whole syllabus. But that is not what we are striving for. We are striving for that even if it takes 2 months extra, it does not matter. It does not matter. What we should get is, we should ensure that you get the required result. But the result is only when you actually understand each and every aspect and learn it. Go back to you. Till the time you don't learn these ideas, how will you be able to connect it after these classes are over? Right now, we are in that process. So I am always talking about it. What will happen once this is over? Just think of it. Right now, I am talking about curative petition. What will happen once constitution classes are over? Then no one will be talking about curative petition. So now you know what is curative petition, but it will not be the case always that every day I come up with with that kind of a topic. No, it does not. That will not be the case. For you it is like, I'll give my best, because I don't have to think about service anymore. I have to think about how to improve. Now this is something that you have to come up with a strategy in this manner, that the first attempt, very important. I have to at least ensure that I get a service in this attempt, and in next attempt it may so happen that you get IAS or some other service that you are looking for, foreign service. Some of you are going for foreign service. So you have to be in that particular mode and in that particular manner. Until unless you have this confidence to think that you can qualify, how will you qualify? And I'm telling you right now, if I tell you to just think, do you think your preparation is worth, for that preparation that you have done till now, do you think with that preparation you are going to qualify? Most of you will answer in a no, in a negative. That should never be the case from day one. If you do that, that is going to create a problem. That is going to create a problem. I'm telling you this because this is a personal experience. I have appeared for UPSC interview 4 times. Forget about prelims. I have appeared for interview 4 times. I know what happens even with a slight mistake. In 2010, it was only 9 marks was less. 9. Just think of it. Only 9. And after 2 attempts, you do not have the energy to give your best. I'm telling you that also. It is so exhausting. It is so exhausting. Don't commit that mistake. Don't have that passive kind of an approach towards the examination. If you have that passive approach, it is going to be a problem. It is going to be a problem. Every morning that you get up, you should be motivated enough to do a certain set of exercises. You should be motivated enough. Getting up in the morning, reading the newspaper, ensuring that all facts, you are ready with all facts, coming to the class every day. Some of you are not regular, and regularity is the principal skill here. I'm telling you, it's not that much as of a that your IQ should be great. If you are not regular in working hard, you have to do a certain set of exercises to actually qualify this examination. And one of them is to ensure that you are reading, you are reading and learning at least what you are taught first, and then you will actually go, that will be like a basic, and you will build on it. As soon as your preparation progresses, you are going to build on it. You are going to build certain, some one story, second story, the third story, and when you get into a mains examination, there are 2-3 types of individuals. First of all, those individuals who appear in mains examination, out of that, at around 50% of them don't care what happens with the result. They don't care what happens with the result. Why? Because they are satisfied just because they have crossed this prelims examination. Now they think that they have already crossed this examination. That is absolutely, that you don't have to worry about those individuals. Then there are the remaining 50% who have worked hard. And out of that 50% that are there, 50% have worked hard, but they have not been able to reach the standard that is required. And the rest 50% that is there, that is 3,000, they are going to qualify as it is. Out of that the 3,000 that is there, some of them are going to get into service. Why? Because once they have built on their basics, and now they are not in the just at the ground floor of it. They are either reach the first floor or the second floor, and that is what ensures you get into this service. Learn whatever you have been taught. I am telling you, if you just go through the previous year papers, you will understand the importance of the classes that you are actually taking. You will understand the importance of it. Whatever you read, if you read the previous year papers, you will find, okay, this is what I have read in the class. This is what I have read in the class. Once you understand that, you know that, okay, if I do at least this much, this is enough for me. Because you have to score only 50%. To top this examination. Forget about qualifying. Only 50%. But you can understand why are we not able to score that 50%? Because most of us do all the wrong things, not the right things. And what you have to do is the right things at the right time. So these 2 conditions, you are not fulfilling these 2 conditions. This is a problem. This is the problem, and this is the reason that I see most of, batch after batch, I see most of you do what? Because you do not understand what is the mistake that you are doing, you repeat the same mistake attempt by attempt, and finally what happens? Finally is that you don't get success. This should not be the case. This should not be the case. It is as simple as that. Because see, preparing for UPSC examination means what, you know? Preparing for UPSC examination means you are wasting your life unless you actually prepare here. Otherwise you are wasting your life. There will be a time when you will regret this time that you have wasted if you do not prepare well. If you prepare well, you will always consider that this is, yes, what I did, the decision that I took was correct. Otherwise you will regret this for your lifetime. I am telling you this. At this particular time you can do anything in your life. Not after 5 years, not after 3 years. At this time you can do anything in your life if you decide to do it. But after 2 years, after 3 years, first of all, you will not have that energy to do that. Second of all, the time that was the most important time of your life, you have already wasted it. Don't do that. Clear? So please remember, revise. Now, until unless you revise, it is not going to suffice. This is not going to suffice.